Following along with the courts, we have alternative dispute resolution, called ADR. Section objectives: to compare the primary forms of alternative dispute resolution, to describe the less frequently used methods of alternative dispute resolution, and to explain court-annexed ADR. Alternative dispute resolution. ADR is the resolution of disputes in ways other than those involved in the traditional judicial process. Unless court-ordered, there is no record, which is an important factor in commercial litigation due to trade secrets. Now, what this is meant to highlight is anytime there is a trial, there is a public record of the trial. Some businesses have processes or lists that are secret that they don't want the public, more importantly, the competitors to know about, right? So ADR is a way to keep any sensitive information out of the public eye. Now, the most common forms of ADR are negotiation, mediation, and arbitration. We're going to start off talking about negotiation. Negotiation is an informal discussion by the parties with or without their attorneys, where differences are aired with the goal of coming to a meeting of the mind and resolving the case. An important thing to remember is that negotiation is informal and it's best used where the misunderstanding is relatively minor and the parties are on good terms. The next form of ADR is mediation. Mediation is a method of settling disputes outside of the courts by using the services of a neutral third party who acts as a communicating agent between the parties and assists them in negotiating a settlement. Now, think of mediation as assisted negotiation. The third party does not decide anything. The third party is nothing but a helper. Now, big advantages to mediation over traditional litigation is that there are few rules. It's a customized process where the parties are really in control. Now, because the parties are controlled and because the parties can create the terms of the mediation, you tend to come up with more of a win-win situation, right? Each party is more likely to get what they want and walk away happy than is frequently the case with traditional litigation. Now, a couple of disadvantages. First is mediator fees. Nothing in life is free. And depending on the skill set of the mediator and what it is the mediator is mediating, it can be anywhere from $100 an hour to $1,000 an hour. Another disadvantage is there are no sanctions. If the parties come to an understanding during the mediation session, and then one party later changes his or her mind, there's nothing that can be done to enforce their agreements. And finally, there is no deadline. Time is money, time is money, time is money on the side of the parties in disagreement. On the side of the mediator, time is profit, time is profit, time is profit. So the mediator costs money and frequently has no incentive to speed things up. In fact, the mediator has an incentive to drag things out. Finally, with the big three, we have arbitration. Arbitration is the settling of a dispute by submitting it to a disinterested third party other than a court who renders a decision. Now, unlike a mediator, an arbitrator is, in fact, a decider. An example of arbitration that most of you may be familiar with would be some of those TV judges you see, like Judge Judy. Judge Judy was, in fact, a judge 30 years ago. But for the last 30 years, she's been on TV acting as an arbitrator, if you look at the show. The two sides come before her. They present their arguments. Judge Judy listens, and then she decides. One of the things that a lot of folks don't realize is that the parties enter into an agreement prior to coming on the show to be bound by the arbitrator's decision. Arbitration, unless court-ordered, is a contractual relationship. That being the case, because the parties agreed to be bound to the arbitrator's decision in advance, an arbitrator's decision is binding. In fact, there are only 3 grounds on which an arbitrator's decision can be challenged. First ground is that the arbitrator's conduct prejudiced one of the parties. In other words, the arbitrator was biased. The arbitrator was in favor of one party over the other, right? That would be the exact opposite of being disinterested. Second ground to challenge an arbitrator's decision is that the award violated public policy. That would make the arbitrator's decision illegal. And finally, the arbitrator exceeded his or her authority. The power granted to an arbitrator is given to the arbitrator by, first, the law, and second, the clients, right? The clients can limit the amount of power that the arbitrator has in rendering a decision. If the decision violates that power, the decision can be challenged. Now, where would it be challenged? Well, since ADR takes the place of a trial, you would appeal an arbitrator's decision at a court of intermediate review, right? If it was a federal issue being challenged, the appeal would take place in federal court. If it's a state issue being challenged, it would take place in a state court. Now, there are a few other types of ADR that we have to talk about, but just so you know, up front, negotiation, mediation, and arbitration are the most common. We start off with an early neutral case evaluation. This is a process that may take place soon after a case has been filed by a court. The case is referred to an expert, usually an attorney, who's asked to provide a balanced, unbiased evaluation of the dispute. The parties can then either submit written comments or meet in person with the expert. The expert identifies each side's strengths and weaknesses and provides an evaluation of the likely outcome of a trial. The evaluation can assist the parties in assessing their case and may propel them towards a settlement. Now, it's that last sentence that's really critical, and that's why it falls in here, right? As a general rule, ADR is faster and cheaper than a trial. Trials can take a long time. Lawyers cost money. Court fees can be relatively high. The longer it takes, the more it adds up, right? What this evaluation does is let them know whether it's worth pursuing or not. Next, we have a mini trial. To be clear, a mini trial is not really a trial at all. Rather, it's a settlement process in which the parties present a highly summarized version of their respective cases to a panel of officials who represent each party, plus a neutral official. And this panel has the authority to settle the dispute. Next, we have a summary jury trial. This is a method of settling disputes by holding a trial in which the jury's verdict is non-binding, but instead guides the parties towards reaching an agreement during the mandatory negotiations that follow immediately. Essentially, it's a mock trial that lets the parties know where they would stand, or where they do stand. Now, finally, we have MedArb and ArbMed. Now, this is kind of a combination of mediation and arbitration, right? With MedArb, the parties first try to resolve their disputes through mediation. And if they can't resolve it, the process switches to binding arbitration. In other words, the mediator becomes an arbitrator. The assister becomes a decider. You'll frequently see MedArb as a substitute for a divorce case, right? And if you think about this, when people are getting divorced, it's basically the ending of a partnership. When a partnership winds down, what do the partners want? They want partnership assets. Now, if the court decides who gets what, either one or both of the parties are likely to be unhappy, so it's likely to be drawn out, right? The idea is if you mediate, if you discuss what you want, and the other party discusses what he or she wants, the outcome will be better for both parties. Now, sometimes, people can't come to terms, and if it looks like that's the case, the mediator becomes an arbitrator and decides. Now, one of the things that's pretty good is because the mediator, who then becomes the arbitrator, has had the opportunity to hear both sides' issues and desires. Once again, the outcomes can be more favorable than at a trial. Now, in MedArb, it's reversed. The process starts with an arbitration proceeding, after which a non-binding arbitration award is issued. Right? Non-binding means non-enforceable. Right? After it's issued, the parties work with a mediator in an attempt to resolve their conflict. Now, where can you turn to for ADR services? Well, in most municipalities, there are government agencies and private organizations, right, that provide arbitrators, right? An example of an organization that provides arbitrators would be the American Arbitration Association. Basically, it's a list of trained arbitrators in specialty fields that you can contact. Generally, their fee schedule is attached. Now, there's something that I want to be clear about. As a general rule, mediators, arbitrators are not attorneys, they're not judges. They can be attorneys, but generally they're not. Right? What a mediator is, what an arbitrator tends to be, is a subject matter expert. Right? For example, something that many of you may or may not be aware of is at the end of the contract term for the New York City Police Department, they always enter into negotiations with the city to increase their pay. The police department, through the PBA, always asks for more money than the city can afford. The city always offers less money than the policemen want. In their collective bargaining agreement with the city, there's an arbitration clause that says if the parties cannot come to terms, the discussion will move to binding arbitration. It always goes to binding arbitration, right? And during the binding arbitration, the police department, they present their issues. The city presents their issues as to why they can't pay whatever the cops want. The arbitrator, who tends to be a labor expert, reviews all of this information and renders a decision, right? Not a lawyer, but a labor expert, right? So there is no requirement to be an attorney or a judge to be an arbitrator or mediator, right? In fact, many mediators are pastors, social workers, psychologists, depending on what is the basis of the dispute. And that concludes our discussion on ADR.